White House and by the Foreign Intelligence Surveillance Court. The idea of this was as follows. Let's suppose that the NSA learns that there's a person in Syria about whom they have reasonable grounds to believe that that person is engaged in potential terrorist activity. And they know this person's phone number. They want to know whether this person is speaking to anyone in the United States who may also be involved in terrorist activity. Because if they are, you've connected dots, and you want to be able to then investigate further to find out whether there's a problem here that needs action. So the idea of this metadata system was basically this. If NSA analysts found that a phone number belonging to someone, say, in Syria, let's call that person X, was reasonably thought to be engaged in terrorist activity, they could type that phone number, not literally, but effectively, type that phone number, query the database for that phone number, so the computer would then examine every phone number with whom that X's phone number was in touch. If any of those Y's, every phone number with whom X's number was in touch, let's say it's a Y, if any of those Y's had independently been identified in advance as someone who was suspected of being potentially engaged in terrorist activity, the computer would spit out that person's phone number. So you'd have two phone numbers now, the Syrian number, X's number, and Y's number. Right? In addition, what the database would do would be to ask for all the Y's, whether we knew anything about them or not, for all the Y's, it would ask who have they been in touch with. So it would scan all the Z's. And if any of the Z's was someone who had independently previously been identified as a person who might be engaged in terrorist activity, it would spit out their number. Okay, so you would know either if X was talking to Y and Y was a suspected terrorist, you would know that. If X was speaking to Y, he was speaking to Z, even if you knew nothing about Y, if X and Z were both people suspected of terrorism, it would spit out X and Z's phone numbers. Because on the theory that if X is talking to Y and Y is talking to Z and X and Z are both terrorists, you want to know. Okay, so in 2012, which was the last year for which we had full year's data, it turned out that the NSA queried the database, typed in 288 numbers belonging to individuals outside the United States who were found by NSA analysts to be reasonably believed to be engaged in terrorist activity. From those 288 queries, the database spit out 12 numbers. So in 12 instances, those 288 people were in touch with someone either as a Y or as a Z who was already independently, separately suspected of potential terrorist activity. And in each of those 12 instances, the data was given to the FBI for investigation. In that year, none of those investigations turned out anything that was alarming. Okay, so that's how the system operated. And this is the program that got the most attention in the United States because it involves the privacy of Americans, because we're all the X's and the Y's. And it's tens of millions of us who are affected. Okay, so we looked at this program, and this is one of the programs Edward Snowden revealed. And the question was, what do we think about this? So, first thing we thought about is that logically, forget about what the actual results were or not, logically, this makes sense. If what you want to do is connect the dots, if you want to see if there's connections here that require investigation, this is a sensible way of attempting to gain useful information. That's number one. Number two is, how useful was it? Well, in the 6 years that it had existed, not just 2012, but in the whole 6-year time in which it existed, it had never produced information that had directly enabled the government to thwart a known terrorist plot. On the other hand, it had been somewhat useful, along with other information, in helping to understand certain situations and certain relationships. Okay, so one thing we might have said is get rid of it. At 6 years, it hasn't hit a home run yet, and it's not worth it. And it does run the risk of invasion of privacy because it's gathering all this information. We should just get rid of it. And in fact, the NSA had an email system that was exactly the same as this, which it itself got rid of because it concluded it was not, in fact, worth the cost. That they hadn't gotten enough out of it to justify the continuation of the exact same program, except with email, unlike the telephone. So one thing we could have said is get rid of it, it hasn't worked. But one thing we thought about with this is a little bit like a fire alarm in your home. That the fire alarm may only go off rarely, and usually, or almost invariably, because you barbecued something in the house and the smoke caused the alarm to go off. But when the battery goes dead, you don't actually say, never mind, the hell with replacing the battery. Right? Most of us do replace the battery, even though we know it could be 6 years, 10 years, maybe never. There won't ever be an actual fire. But it's worth having it because if there is an actual fire, you want to wake up. Right? And our sense about this program is that it had a certain logic to it. So that even if in 6 years it hadn't hit a home run yet, we hadn't had a fire yet, that didn't mean in the next 6 years there wouldn't be a fire. And it might not be critical in connecting the dots in a way that would be important. But even so, the concern was that, so what's the privacy issue here, right? Why should we care about the privacy of this metadata? So one argument is that you shouldn't care about it. It doesn't tell you anything about the content of the phone calls. It doesn't tell you anything about what you said to anybody else, right? It's just numbers. On the other hand, those numbers, when analyzed, can reveal a lot about a person. It can reveal about whether a person is having an affair, or seeing a psychologist, or is gay, or who his political buddies are, all sorts of stuff that you can actually go in there and analyze the phone messages, the phone data, can reveal a lot of information about an individual. And the concern that we had was that even though the NSA had not abused that data, that you could always wind up with another J. Edgar Hoover or Richard Nixon or Lyndon Johnson who would say, I want to find out about so-and-so, right? You know, we got that database over there, go figure out who that person's been talking to, right? And it's all just now sitting there. And that is nervous making, right? So one thing we recommended was 2 changes to be made in the program. The first is that the NSA should not be allowed itself to determine whether there is reasonable grounds to believe a phone number belongs to a person who is engaged in terrorism. That there's no reason why that judgment shouldn't be made by the Foreign Intelligence Surveillance judge rather than by the NSA analyst. And second, that the NSA should not be allowed to retain the metadata itself. That is, the metadata should be left in the phone companies, where it is anyway, where they hold it for 2 years for billing purposes, no matter what. And that when the NSA can demonstrate to the Foreign Intelligence Surveillance Court that it has reasonable grounds to believe that a particular phone number belongs to a person engaged in terrorist activity, the court can issue an order to the phone companies to do this search and then spit out to the NSA whatever matches may occur without the NSA itself ever having any access, or the government ever having any access to the data itself. So the goal here, this is representative of the challenge. The goal here is to figure out, are there ways to preserve the national security value of a program while minimizing the dangers to privacy and civil liberties? Right? How can you keep the value and limit the danger of abuse? And that was, in large part, the approach that we took in analyzing the various programs that we were asked to look at. A second example of this, in a somewhat related context, is the Foreign Intelligence Surveillance Court, when it was created in 1978, it was assumed that it would operate in the same way that an ordinary judge operates. When a police officer goes to the judge and says, I want a search warrant to search someone's home. And the judge would decide whether there's probable cause and would issue the warrant or not based upon the judge's determination as to whether there was legal cause to conduct the search. And that's the way it works all the time in the world of warrants. But one thing that we realized here was that sometimes the issue presented is not just, is there probable cause or is there reasonable suspicion, but should a statute be interpreted in a certain way so as to authorize a complicated program that's not explicitly authorized by the statute. Telephone metadata program is a great example. When it was passed, Section 215 was not thinking about sweeping in billions of bits of data. That was not what it was about. It was about going to a car rental company and getting somebody's car records, right? And the Foreign Intelligence Surveillance Court held that the 215 provision could be interpreted fairly to authorize the metadata program. That's a very hard, complicated, legal, statutory interpretation question. And so one judgment we reached is that in situations like that, there should be an adversary system. It should not just be the government lawyer going to the judge, making the government's argument for why they should be allowed without the judge hearing the other side. And so we recommended the creation of a privacy and civil liberties advocate who would have top secret clearance and who would be able to appear before the Foreign Intelligence Surveillance Court to argue against the government's positions in this secret world that certain programs that the government's arguing for should not be authorized because they're either not consistent with the statute that's relevant or with the Constitution. Okay, so those are just two simple examples of the kinds of recommendations that we made. I choose those for two reasons. One is because they're the ones that most directly affect Americans. And second, because both of them were adopted by the Congress in the USA Freedom Act, which was enacted in June. And in fact, the recommendation about the metadata program took effect yesterday. So as of yesterday, the government no longer has the metadata. It all now is held only by the phone companies, and the government no longer has tens of billions of bits of data, which has now been destroyed. I recommend, by the way, reading the report. These issues are of interest to you. It was intentionally written by us for a general audience, even though it deals with a whole range of programs, most of which I haven't obviously mentioned. And it was actually published by Princeton University Press, and we get no royalties as a government document, so I'm not pushing it for my sake. But if these issues interest you, it's a pretty accessible explanation of what a range of different programs, way beyond the ones I've talked about today, look like, and how they operate, and whether they need to be reformed, and in what way. And if you're interested, you can just Google NSA report, and you'll find it on Amazon or whatever. Okay, I think with that, I'm going to stop and answer questions. I know we only have 15 minutes left. So, questions? Yes?
You obviously touched on the two programs that are probably most well-known, but were there other programs that you observed or that you became aware of that you had greater concern about than the ones that you touched on today?
So the 215 program is the only one that is explicitly directed against American citizens. Okay? There's a huge number of foreign intelligence programs that are directed at non-U.S. citizens not in the United States. And that's the vast majority of what the NSA gathers. So the largest of those programs is one authorized by Section 702 of the Foreign Intelligence Surveillance Act. And what it basically authorizes is the NSA to gather content, not just numbers, content of emails and phone calls when the target of the collection is a non-U.S. person, not U.S. citizen, who is outside the United States, where there's reasonable grounds to believe that the communication is relevant to the investigation of terrorist activity. So this means that if the United States wants to listen in to phone calls or read emails of a person with a particular email address who lives in, let's say, Syria, right? And they can demonstrate that they have reasonable grounds to believe that that person is connected to terrorist activity, then they can gather all of that person's emails. Right? In the same way that if you're investigating a person for murder in the United States, you can wiretap all of his phone calls. Right? So a huge amount of information is gathered here because there's a lot of people around the world in total who are suspected of being engaged in terrorist activities. And so the government gathers a massive amount of data in those circumstances. So there are several issues with that. The first one is that you could not do that to an American citizen without probable cause. Right? Probable cause is not the standard when we're dealing with people who are not U.S. citizens and not inside the United States. Right? So one argument one could make is that we should treat people around the world exactly the same way we treat American citizens. And we should not read their emails or listen to their phone calls unless there's probable cause to believe that they're involved in terrorist activity, which is a much higher standard than reasonable grounds to believe. Our own view is that that's not necessary. That we all treat our family differently from people outside our family, and we give benefits to people in our state that we don't give to people outside our state, and there are human rights rules that provide a floor of what you can do. But these programs were not in violation of those human rights privacy guarantees. They present sensitive issues because when the people in another country learn that we can do this to them, they get pissed, right? And then their government officials pretend they didn't know and say, oh my God, I can't believe they're doing this to us. This is an outrage. But of course, they've been reading the emails themselves when they've been given to them by us when we find out that someone in their country is a potential terrorist. But there are international relations issues there and human rights issues there. But those were not, in our view, we were not doing anything there that was particularly wrong. The tricky part there comes in because of what's called incidental collection. So if I'm suspected of murder and the police wiretap my phone or read my emails because they have probable cause to believe that I committed a murder, they were going to see all sorts of information involving third parties who aren't suspects. Everyone who calls me, everyone who emails me, their emails, their phone calls are going to be collected, and the government's going to see this information about them, even though they've done nothing wrong. All they've done is talk to the suspect, not knowing that he's a suspect, right? And ordinarily, what we do in those situations in American law is, unless the information about a third party reveals that the third party is engaged in illegal activity, right, we destroy the information. The question is to what extent the same thing should be done in the international context when American citizens are the ones who are on the other end of the phone call or the other end of the email. And what we recommended is that the same rules should apply, and that all of that data should be destroyed when it's determined that the person on the other end is an American citizen. Now the problem is it's hard to know that with emails, for example. Right? You don't know who this person with a Gmail address is. But if the government knows that it's a person who is an American citizen, we recommend that they have to be destroyed. And we also recommend that the government should not be allowed to search this massive database for any information about an American citizen, which is incidentally in the database, right, without going to a judge and getting a warrant based on probable cause. So if they now suspect you of some wrongdoing, and they have this massive database of emails with terrorists outside the United States, in theory, they could just go and search your email address and say, gee, let's see what this person has been up to, right? Our recommendation is, no, you can't do that, right? That's not why we're gathering this information. We're gathering this information for different purposes, not to enable you to find out about American citizens. And that also has been adopted now. Yeah.
National security letters give a government agency pretty thorough access to your browsing history, emails, that kind of thing. There have been a couple reports of web companies who've attempted to provide encrypted email services, and these email companies reside within the United States. The reports are that the government would rather these internet companies don't run encrypted web services. They would rather have unencrypted emails kept in these mail servers. Is that, do you expect that to be the status quo for now and for the time being?
So the problem here is this. Let's suppose, right now the government is able to wiretap if it has probable cause and a warrant. Right? Let's suppose that technology made it impossible for anyone to wiretap, including the government, including with probable cause and a warrant. Right? Should we allow the phone companies to install technology that would prevent the government from doing what would otherwise be a lawful wiretap by encrypting the phone lines in a way that would make a traditional wiretap impossible? Right? The argument from the privacy side is that, well, we don't want people being able to get into these information, get into this information. So the government's argument is that you don't want to do that. You do not want to make it impossible for the government to do legal interception, right? Whatever the standards are, probable cause, reasonable suspicion, whatever it is, if they meet that standard, you don't want to make it impossible for them to gather the information by encrypting the technology in a way that makes it impossible for them to gain access. That's the argument of the government, right? We recommend against mandating backdoors. So we recommend that insofar as encryption is being used, the government should not be able to insist upon having essentially a key to decrypt the information. And the reason for that, it's a complicated issue, because if you had that on the phone tap, it would be the example I just gave, which would be the government could no longer tap phones. But the reason for that is basically because in the world of internet technology, if the government can get in, then so can lots of other people. And that hasn't been a problem with wiretaps. Right? In the wiretap world, you can wiretap somebody else right now. Right? It's illegal, but you can do it. Right? But the fact is, it doesn't happen very often, so we don't actually think it's a big problem. But the assumption is that, and probably the reasonable assumption, is that in the world of internet technology, that if you can break into an encrypted system, that there'll be lots of hackers out there who want to do it. And you can't enable the NSA to do it without making it possible then for a hacker to do it. And so it's a straight policy trade-off question, right? Which risk do you think is worse? Denying the government the ability to do what is otherwise legitimate, and now so you're not going to be able to do that because we're not going to let you decrypt. At the price of, if you let the government do it, you're opening the door to others being able to hack as well. So it's a problem right now. Our recommendation was not to mandate backdoors and to keep the encryption and not give the government decryption. And that infuriated a lot of people in the government. And that's still it's an open question right now. And the law hasn't resolved the question.
Follow-up question, if you don't mind, is you mentioned that the metadata is now under has an adversarial system where you have someone arguing against granting government access. Is there a similar system in place for national security letters?
So I'll explain what national security letters are and so on, and the answer is no. Okay. One of the recommendations we made was that, so here's what a national security letter is. Ordinarily, the police, as I said earlier, can go to a judge and get a subpoena, or a prosecutor to issue a subpoena to get, for example, somebody's car rental records. Right? So you want to know who rented a car that was seen driving away from a bombing. Okay, so you can go to the Hertz and you can find out who rented the car, and they go with a subpoena and they demand the information. Okay, so in the national security context, you couldn't do the same things. You couldn't go to a judge because the judges don't have top secret clearances. So they created what are called national security letters. And national security letters authorized the FBI, in particular, to demand information from, let's say, car rental companies or telephone companies or hotels or whatever, about information that they have in their possession. And they're able to do that on their own determination that there's reasonable grounds to believe that the information is relevant to a terrorist investigation. And we recommended that they should not be allowed to do that without going to the FISA court, to have the FISA court make the determination that there were reasonable grounds. And Jim Comey, the director of the FBI, who, by the way, is another former student of mine, objected strenuously to this. His argument was that a prosecutor does not have to go to a judge to issue a subpoena. So why can't the FBI issue a subpoena also without going to a judge? Right? And our argument was that the difference is that when the prosecutor does it, it's public. And it can be challenged and tested in court, and that itself poses a constraint on the prosecutor abusing the authority. But the national security letter issued by the FBI officers is all top secret. And the vast majority of them, no one will ever know they were issued or what was learned in them, unless there happens to be a criminal prosecution, and even then, they will generally keep them classified. And so the constraint of visibility on abuse doesn't exist. And so we recommended that for that reason, they should have to go to the Foreign Intelligence Surveillance Court to get a judicial order to issue the national security letters. President Obama was persuaded by Comey, apparently I taught Comey too well, and declined to adopt that recommendation. And the Congress also has not adopted that recommendation. And I think that's unfortunate. I actually think there's no good reason not to require them to go to a court as long as time allows, and to get that independent judgment. I think I'm supposed to end at this point. Thank you very much.